The state, once all these claims have been filed and tabulated, then the state sends out an investigator, water masters and engineers, to look at the systems and try to figure out among the claims whether there is an adequate amount of water there to support these claims, that the points of diversions are actually where they say they are, where the ditches are where they say they are, where the whole infrastructure is supposed to be verified by this investigation. That's done by the Oregon Water Resources field staff. The Oregon Water Resources Department then compiles a preliminary order of determination using all that information from the investigators. And they contact all of the people with water rights and certificates in that area that could be affected by this adjudication, and provide that determination, the preliminary determination to them, as well as they make all of the information available from the investigation of the claims becomes open to the public for a period of time for inspection. And that, folks, is where it hits the fan. Contests are made, and the Oregon Water Resources Department holds administrative hearings on those protests. Administrative law judges hear all of the arguments on both sides and come to some conclusion in each of the contested cases. At the end of that time, the Oregon Water Resources Department then gathers all that information together, puts it together with the claims information and investigation information, and the Oregon Water Resources Department then makes their determination and order of proposed decree, and they submit that to the local circuit court. Once that is submitted to the circuit court, the Oregon Water Resources Department then has the legal authority to begin to regulate water according to their determination. They can come and rule the junior people off. I mean, that's what they do. You can have a stay of that determination by filing a bond or a letter of credit with the court that says that I don't believe that this determination is correct, and I'm willing to put up this bond to continue to use my water because I intend to prove that it is my water. If you are successful, obviously the bond isn't used. If you're unsuccessful, the bond is paid to the other water right holders. Once the circuit court has the final determination from the Oregon Water Resources Department, that is the time when exceptions can be filed. And once again, the process in essence starts over again, in that each individual who believes that the determination by the Oregon Water Resources Department is insufficient and incorrect has the option to and the ability to argue that in the circuit court. And each of those, that is a civil proceeding without a jury, decided by the judge. And at the end of all those exception hearings, the circuit court will then issue a final decree. And that decree becomes the law. The decree can be appealed to portions of the decree of your particular claim could be appealed to the appellate court. And then you can also acquire a bond or a letter of credit to continue to use your water during the time of that appeal. Once the appellate court has ruled, you can appeal that to the Supreme Court, and if the Supreme Court should agree to accept your case, then they would make the final determination. Otherwise, the appellate court is the final determinator in the adjudication. Now, there are also tribal reserved rights. Under the Adair decisions of the Ninth Circuit Court of Appeals, they did establish that the tribes do have a water right, and that water right has a priority date of time immemorial, so it can't be trumped. They left up to the states, the Ninth Circuit Court left up to the states specifically the adjudication of those water rights, the quantification, how much water, what is the rate and duty that the tribes actually have a right to use. The Ninth Circuit Court also said, in one of their rulings, that that amount should be no more than is required for a moderate living standard as it was used at the time that the tribal reservation was terminated or sold. And we also have the federal reserved rights, which are created under the Winters Doctrine. I think that was 1908. And the federal reserved rights essentially are those inchoate rights that the federal government has to water to maintain their forests, to maintain their meadows, to maintain their fish and game habitat and so forth. The Winters Doctrine was modified in 1958 by the McCarran Amendment, which again reestablishes that the state has the authority to adjudicate water within the state, to divide it up as the state sees as appropriate, so long as that process is judicial in nature. If it is administrative in nature, the McCarran Act does not apply, and the federal government would not allow their water rights to be adjudicated by the state. And then there's also the Allotee Act, that during the time when the reservation was in force, the Allotee Act allowed members, tribal members, to actually acquire a portion of that land for themselves individually, and a water right went with that. That is further broken down into those lands that tribal members still own, and those lands that tribal members have sold to a non-tribal interest. I'm not trying to even try to get into the legal aspect of that. As I said, I'm not a water attorney, and as certified smart water attorneys argue this point day after day after day. So, but it is a convoluted and complex process. And it should be, because we're dealing with your water rights, and your water rights are a very valuable property right. In 2001, when the water was turned off to the project, Reggie LeCue, our county assessor, reassessed those lands that had lost their water for 1 year from an average of about $25 an acre to an average of $21 an acre in value. Particularly in Oregon, where we have our centralized land use planning, which doesn't allow you to use your land for something else. If you lose the irrigation water, it once again becomes sagebrush steppes or alkali flats. So the water right, obviously, and I'm not speaking to the choir here, but the water right has a huge value to each and every one of you. This adjudication process has worked for 100 years. It is a time-consuming and difficult process, but at the end, each person does have their ability to have their day in court, to have their day to their opportunity to defend their water rights.